Well, welcome back on the AM show. Time now to discourse on the ever-popular election petition, 2020 election petition. It's been some 53 days of legal tussles, and here we find ourselves discoursing on what exactly has been happening so far in the Supreme Court. Joining me for the discussion, Joseph Akable, our court correspondent, and there's a whole lot we're going to be getting into. Joseph, a very good morning to you.
Good morning, Ben.
Great. So let's start from here. After all this time, some 20 plus days of, actual sittings in court, and then 53 days, if you like, of the court sessions, let's take a quick look at what has been happening so far, some of the highlights.
And so a lot of key events, and so obviously the first issue that the court dealt with, we'll go through the rulings that have come by way of the main highlights. And so we had the first day where they went over and they had to make a request to be allowed to correct mistakes. From there were issues related to witnesses having to come in to be cross-examined. There was also the bit about various requests that were made to the court in between the hearing. Then various arguments about whether or not the AC chairperson should testify or not. Then finally we've had a date fixed for judgment. And so that is an overview of where we have come from. A lot of people were looking out for the trial proper, the cross-examination, unlike 2012, 2013, where it lasted for a number of months. You had Dr. Baumia going into the box, you had Mr. Siodin Ketia. And this particular instance was very brief because of the approach that the court adopts. You file a witness statement, you come, you are sworn in, you rely on a statement, then you are cross-examined. And so we didn't see a lot of the interaction like we did see in the 2012, 2013 case. But
one of the most important bits, the bit about interrogatories, which were not allowed, and how it has devolved into the entire case, because now claims being made about, we felt that by not granting us the interrogatories, by the processes of the court, we would have the opportunity of examining or cross-examining Jean Mensah, and that has not panned out. In fact, when we take a look at the number of petitions that have been put through, or motions that have been put through by the petitioner, we'll see that quite a number of them have been debunked by the Supreme Court. But key highlights from yesterday, because that was another very interesting session. Chachu still, they're having quite a banter with the justices of the court, the bench, and of course, Dominic Ayine's issue as well. Let's start with yesterday's highlights. And
so the main business for yesterday had to do with a request that had been made that the petitioner be allowed to reopen his case. And I mean, in simple terms, for those who may not be familiar with the legal process, when you go to court, the person who has filed the case tells his side of the story. Once he is done, he informs the court that I am done with my side of the story. And so the respondent or the defendant in how the case may look like will now be called upon to tell his side of the story. You recall that after Mr. Chikata had informed the court that the petitioner had closed this case, the EC opted, and the second respondent opted not to give any evidence, i.e. calling any witness to come in to testify. And so they had asked that the court compels the EC chairperson to testify. The court turned that down. They filed for a review of that. It was also shut down. Then now they made a request to be allowed to reopen the case. Given another opportunity, what was the end goal? The end goal was to have a subpoena issued against the EC chairperson, Jean Mensah, to testify as an adverse or hostile witness. That was shut down. Then they filed for a review of that yesterday. And so first the court heard the legal arguments. Mr. Chikata quoting from Hosea 8, verse 7, talking about sowing in the world.
And that is something they do.
Yeah,
both lawyers and justices of the court, when they are praying, the court to do something, sometimes they fall on, if you like, the moral argument, though the moral thing does not really factor into the law.
The court actually responded to that. You realize at the end saying that it's a court of law and it will dispense justice on the basis of law and not on mere suppositions and other things like that. And so Mr. Chikata had made a point that they think it was unfair that the court did not allow them reopen the case because there are matters that they intend to obtain by way of questions from the EC chairperson, who they insist had told them per an affidavit that she swore while opposing their request to serve interrogatories. She had indicated that those interrogatories, i.e. the 12 questions, could be put to her during cross-examination. But we heard the EC's lawyer, Justin Amenuvo, and President Akufo-Addo's lead counsel, Akoto Ampao, argue against Mr. Chikata's request. And the point that they made was to the effect that a losing party, if you've lost, the review is not a mechanism to appeal your case. It's a small window that you would have to come and demonstrate that there are exceptional circumstances that has occasioned a miscarriage of justice, and so the court should allow you go in. Mr. Amenuvo made an interesting argument, which was, for me, what the court centered on in deciding. The point he made was that the court on February 16, when it delivered its decision, it turned down the request not because of any specific law or anything. It exercises discretion by saying that, look, you are asking us that you want to reopen your case, but you have not demonstrated what evidence you want to obtain from the EC chairperson and how that will materially affect the case. And so he believes that that was the reasoning of the court. And so if you are going to demonstrate that the court made any error, you should be pointing to how that is in error. And how are you going to, point out that a discretionary power has been exercised in his view that amounts to such an error to be committed. And so he advanced that in addition to other arguments, and the court upheld that argument and proceeded to interestingly clarify various aspects of its earlier decision that had been rendered, and effectively shut the door on the petitioner's quest to have the EC chairperson enter the witness box. And so for those who are looking forward to a date between Mr. Chikata and Jean Mensah, it's not going to happen.
Well, that date, it just wouldn't be March the 4th. That is for sure.
Not at all.
So substantially, what was the argument made by, Lawyer Chikata, the lead counsel for the petitioner, on the floor? Because these very same things that you are indicating now, first of all, even when it comes to the bit about reopening the case, there were suggestions with regard to closing your case and now wanting to reopen, whether you have, like you're saying, what it takes to reopen the case. So specify for us in court yesterday, what exactly was the court focusing on to say that, look, you have not met the standards required to reopen the case?
And so Mr. Chikata had urged the court that, look, when the court was ruling on the decision not to reopen the case, the court made some comments about an adverse and hostile witness, and the court relied on the Black's Law
Dictionary came in.
And he said that, look, you should be looking at the Section 72 of the Evidence Act, which that definition suits the purposes which they are intending to urge on the court, i.e. to say that this is a witness who, by way of the person's interest, is adverse to our cause, but we want the person to come in and testify. But the argument that the other side made was that that witness was not coming in. The provision that Mr. Chikata had made reference to had to do with when you are leading evidence, and as far as they are concerned, in this instance, the case had been closed, and so it was a completely different ballgame. Mr. Chikata again makes the point that the way the court applied subsidiary legislation in interpreting and holding that the woman cannot be compelled to testify, and in this case, they cannot even allow, they are not going to exercise that discretion to allow them to reopen the case. It's suggested that they have put a subsidiary legislation above an act of parliament. And then again, when the court was ruling on the matter, the court clarified that as well. And he made references to the need for a fair trial, and that is guaranteed in Article 19. And he says, this is a trial that you wanted to serve interrogatories. You wanted to inspect documents, it didn't go through. You wanted to serve interrogatories. You were told that you can ask during cross-examination. And as far as he is concerned, the common law principle of promissory estoppel, i.e. you have made certain representations to you such that you have relied on those representations and it has led you to a certain conclusion, the court should compel you to stick to it. And he's saying that once the EC chairperson said in that particular affidavit that those are questions that you can ask me during cross-examination, she had elected to testify and she was bound to testify, and the court should compel. And so if the court has earlier ruled that she cannot be compelled, they are asking to be allowed to reopen the case. And it was for two critical issues that they wanted the case to be reopened to deal with. One has to do with the issues of vote pardon that Justin Amenuvo put to Mr. Roger Metununu and Pesawaiti during cross-examination, and Mr. Seydou Nketiah as well. And so that was the issue. And also the second issue about whether or not the AC chairperson told them to go over and confer with John Mahama, which point brought in the whole bit about tea and biscuits.
Yeah. I don't know whether you take biscuits with your tea, but that was another interesting development that came up. But before we talk about other matters that, emerged yesterday and even what to look forward to ahead of March the 4th, there is this issue of the number of motions that, the petitioner has put through. You look at the petitioner's motions, you look at the respondent's motions, the first respondent, for example, the Electoral Commission, and then you look at, the second respondent, Nanado, and his team. I think Nanado has so far, I don't know whether they have put in a petition yet, but at least the petitioner, the petitioner has come out with a number of respondent as well. Maybe we should just take a quick look at that. and give a breakdown about those that have been accepted, those that have been dismissed, and what it looks like, the picture so far?
Yes, and so we are broadly classifying them as 11 requests that have been made so far. And so the cases, first, the court unanimously granted the petitioner's request to amend the petition, i.e. correct minor mistakes that did not affect the substance of the petition. These were issues about calling for a runoff as part of the reliefs between the EC and Mr. Mahama instead of the Mr. Mahama and Nana Dankwa Akufo-Addo. And so the court granted that. Secondly, the Supreme Court then constituted as a 9-member panel unanimously dismissed a request to substitute a paragraph and add additional ground in a push by the petitioner to have the interrogatories ruling reviewed. And so that was another thing that was dealt with. Then this 9-member panel also unanimously dismissed the review of interrogatories itself. So that was a 9-0 decision.
Then from there, if we can move to the next one.
The next one, the original 7-member panel by unanimous decision struck out portions of the petitioner's witness, that is Johnson Esiedun Nketiah's statement, 7 paragraphs specifically, while maintaining 3 parts following a request by the respondents.
So that was another one to look at, another one that came up. And then the next one.
This panel also unanimously dismissed the request by the petitioner for documents to be inspected. These were the pink sheets that they wanted to inspect and run copies of.
Which they were expecting from the Electoral Commission.
Yes. The panel unanimously struck out 5 parts of 32 paragraphs of the petitioner's witness statement, Rojo Metununu to be specific. The panel unanimously rejected the petitioner's request to compel the Electoral Commission to call Jane Mensah to testify. The panel unanimously dismissed the petitioner's request to reopen his case. The enhanced 9-member panel dismissed the petitioner's request that it reviews its decision not to compel Jane Mensah to testify.
Okay.
And the Supreme Court formed a 9-member panel which unanimously affirmed an earlier ruling that stopped the petitioner from reopening his election petition as well. And so if you put all together, you realize that, and include one other minor one that I was taken out, you realize that by way of the accounting, and yesterday when we were having a conversation on radio, someone said the words unanimous and dismissed were in it, a lot of them. And so by way of summary, in terms of the petitioner, the only one occasion that the petitioner has had his side of the argument upheld entirely by the Supreme Court panel, just once, when they were asking that the court allows them to correct the minor mistakes in the petition.
Which was granted. Which
was granted. So that's the only time. Yeah. Then there are what we can call in football terms draw. That had to do with Johnson Esiedun Nketiah and Rojo Metununu, the portions of their witness statements that they had to strike out. And so in that instance, you can call it a drawing that the number of portions of it that the petitioners wanted struck out, wanted maintained, as against the ones that the respondents wanted struck out, the court more or less satisfied both sides. They give some here, they give some here. So there are 2 draws in that regard. And you have 8 occasions that you've had the petitioner's argument that has not swayed the court, and rather the respondents have carried the day. And so for those who are interested in the scoreline, it's 8, 1, and 2 draws. So that is by way of the scoreline. I don't know.
By way of the scoreline. That's interesting. So it's
8, 1, 2 draws. So the football guys, they will do 3 points by 8, and they'll add 1 point each on both sides and see.
Well, it's been interesting, but it's not looked very good for the petitioner in this case. But of course, we're waiting for March the 4th, where all of this is going to culminate, hopefully, or come to some end finally. But what should we anticipate ahead of that? Because there's been a whole lot that has happened between day 1 of the court session and now. What should we anticipate ahead of March the 4th?
So there are 5 questions that the Supreme Court would ask. It's not too far away, just next week Thursday. March 4 makes it seem a bit far, but just next week Thursday. So there are 5 questions. One is whether or not the petition discloses any reasonable course of action. If this receives a no answer, then it means that the other questions may not be relevant anymore, because if there is no course of action, then and the court will not proceed to answer the other question necessarily. But the second one is whether or not, based on the data provided in the declaration of the first respondent and second respondent as president-elect, no candidate obtained more than 50% of the valid votes cast as required by Article 63.3 of the 1992 Constitution. This is the provision that says to be declared as president, you need to get more than 50% of the votes cast. And number 3 is whether or not the second respondent still met the requirements of the 1992 Constitution threshold by exclusion or inclusion of the Petitioner South constituency results, and whether or not the declaration by the first respondent dated the 9th of December 2020 of the results of the presidential election conducted on the 7th of December was in violation of Article 63.3 of the 1992 Constitution. And finally, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. And so these are the issues that the justices will answer on Thursday. And like I said, if you obviously answer the first one, then the responses will flow for the
So that first question, critical. And I'll be coming back to you for us to discourse on this whole bit about Dr. Dominic Ayine, a former Deputy Attorney General, the bit about his statement with regard to some predetermined posturing by the court and what it has culminated in. But let's have a brief interaction with lawyer Bobby Benson, who's joined the conversation before we wrap with you, Joseph Akable. Lawyer Benson, a very good morning to you. Thank you for joining the discussion.
Good morning, and thanks for having us. If we be allowed to make a...
That's unfortunate. It appears we've lost lawyer Benson, but we'll try to reconnect. So let's quickly go to Dominic Ayine's issue. Yesterday, quite a lot arising, culminating in his apology.
Cited for contempt, yes.
Public
so
apology.
It's a comment that he had made in one of our interactions with him after proceedings, where he said the way in his opinion, the court had reduced the issues to one issue. He says it's marks of a predetermined agenda. That's what he said. And the court cited him for contempt, hauled him before the court. And even before he showed up, he had written to the justices to apologize. And so the letter was circulated amongst them. Then he came in with a respected member of the Bar Association, a former president of the Ghana Bar Association, Frank Beecham. And the justices, Justice Yarapel says he wears two caps. He's a politician and a lawyer. And when he's talking in either stances, he needs to...
And he knows how to juggle them depending on where he finds himself.
So he needs to be mindful of that always, especially when he's speaking on legal issues. And the concern for Justice Yarapel was that there are a lot of people who insult judges, in his own words, and they have no idea about the law and what is going on in the courtroom. And so when they hear respected members of the Bar Association also make such comments, it encourages them to continue to denigrate.
Because they should know better.
They should know better. Right. And that doesn't help the cause of justice, because he believes that the courts, and a reference was made to how our judges are respected. The CJ said some of the judges, even high court judges here in Ghana, are sent to the regional courts and they become the presidents of the panel there, as against Supreme Court judges from other countries. And so they believe our judiciary is held in high esteem, and the only way to protect it is to avoid such comments that will encourage others to attack the judiciary. And so they had reservations about those comments.
Do hold your horses, Akable, and we'll wrap up with this conversation shortly. But let's get back online with Bobby Benson, who's a lawyer. If you can hear me, Mr. Benson, thank you very much for joining us once more.
Yes, I can hear you. Sorry about the drop in the line. I was going to make a preliminary observation or comment to your colleague's analysis about the scoreboard. I think that there was an instance where the petitioner applied for Mr. Metal Nunu to be called as a witness, when originally he wasn't part. He didn't submit his original statement. Another application was granted. So maybe you would want to correct your scoreboard with that score also for the petitioner. And interestingly, on all the 8 applications that the petitioner has lost, if I may use that word, you notice that they all arise from one single issue. Their desire to first, they brought an application for discovery for the Electoral Commission to bring certain documents, and then the interrogatories, and then the application to recall, to reopen their case, the application to subpoena, and the reviews that have arisen or followed up from these applications. So even though the number looks like 8, but you realize that they all border from one issue. And so that if you situate it in the context, then it will make it easy for people to understand that scenario.
Well, thank you very much for that additional information. Very useful there. But I want to dig into the matter with you, starting from the standpoint of what was made clear by the Supreme Court yesterday with regard to not opening up a Pandora's box, so to speak, with certain decisions of the court that could trickle down to the lower courts. So a lot of people have spoken about the letter of the law or the Constitution and the spirit of it in application in terms of the law court. What do you make of that?
Well, ours is an adversarial system of litigation, and that is governed by time-honored principles, both at common law and then supported by statute. The ratio of the Supreme Court in that instance relates to the right of a party to come to court and then insist that to be able to prove his case on the balance of probability or discharge the burden of proof on that party, then you would have to be allowed to call the adversary that you are bringing to court to testify. So that if I decide to sue multimedia, then I can decide not to testify, but then I would insist that multimedia should testify. Remember, the petitioner himself opted not to testify in this case. And he was not forced to testify by the court because it is your case. And you decide to do it how you want to do it, whether you want to testify or not. But you cannot force an adversary to come and testify. And so the Supreme Court, in making that statement, wanted to suggest that, listen, if we grant this application and we allow the the first respondent to come and testify, it will mean that we are opening the box so that people can just file writ or commence actions, and they will opt not to testify, and then insist that the adversary against whom they are coming against should come and testify. If that happens, it will belie or set aside the time-honored principle that any person who comes to court bears the burden of proof, and that you win on the strength of your case and not on the weakness of the other person's case.
Right.
So that the rules of common law and as admitted in our practice is that if at the end you decide as a plaintiff or as a petitioner to say that, my lord, I have closed my case, I do not intend to call any more witness, the fact that evidence that you have led should be sufficient to either make the court make a determination on your claim or otherwise. So that the other side has no obligation to come and testify. In the same way, you, as the person who goes to court, you do not have an obligation to testify. You can call witnesses to testify on your behalf. And in this instance, you see clearly that the petitioner opted not to testify and decided to call Mr. Metunono and Mr. Asiedunketa to testify. And so if they decide not to testify, then they should allow the other party to also exercise his or her right not to testify.
Okay, Lawyer Banton, so
yes.
That point clearly made. I just want to find out from you, was there any avenue, any law that maybe the petitioner did not take advantage of? Is there, so to speak, any loophole in the law, if I may just put it mildly, that could have been tapped into to sort of give a different picture to this discussion we're having? Because while we have this adversarial system, not an inquisitorial one, is there any mechanism that could have been used to ensure that Jean Mensah would actually have to testify? Is there any such, provision in our law books?
Well, because Jean Mensah was the Electoral Commission, represented, of course, by Madame Jean Mensah as the chairperson, is the returning officer of the presidential post. Then, by extension, she's a necessary, or her institution is a necessary party to the action. If she is a party, then you may not have any other means of coercing up to come to testify. And so, it is a legal venue that they could have exhausted or they could have used to achieve that aim. I think rather, it seems to me that the petitioner with the...
It appears the connection is not so good. If you could just repeat that last line and move on, Lawyer Banton, as we wrap up.
Okay. So what I said was that it seems to me that because the Electoral Commission is a party to the action, there is no law that allows the other party to have the court to order a party to an action to come and testify. If the Electoral Commission was not a party, then you could have subpoenaed that person as an expert witness or someone who has evidence. Because the person is not a party, the person must be made to come and testify. And it seems to me that the petitioner went into the election petition with a strategy that is hinged on the Electoral Commission testifying.
Right.
And once that situation did not happen, then it seems as if that they did not, they may not have exhausted or thought through their strategy very well.
Well, Lawyer Banton, thank you very much for the insight this morning. We're grateful for your time and we wish you the best of the day. Coming back into the studio, Joseph is still here. So to wrap, what should we expect on March the 4th?
Even before March 4th, there is a little issue that the court will deal with tomorrow. It gave an order that Dr. Ayine should purge himself of contempt using the same medium. He spoke to us again and apologized and retracted. And so tomorrow, on Thursday, the court will sit just on the contempt issue. And so the court will decide whether he's satisfied that he has purged himself of contempt. If they are, then they will strike out the action. If not, then they'll proceed to give sanctions. And so once that is out of the way, we're expecting that by close of today, the petitioner files his closing arguments, which will be a legal analysis of the case of the petitioner, an analysis of the evidence that has come up so far, urging the court to rule in their favor because they couldn't comply with the earlier order to file it by 17th of February. And so they are supposed to do that by close of day today. Okay. Then on Thursday, next week Thursday, the 4th of March, would have the judgment. And we all know whether we are going to have a runoff, which is what is being called for, or the status quo remains.
Well, I do not know. The Supreme Court will have to decide on that. I've noticed that Lawyer Kotampao is still using his wig, and I see that Chachu's own is also very old. There was a day
Justice Mafusau told Mr. Chikata that he doesn't need a wig anymore. You know how he said that?
Why did he say that? Is it his hair? The color of his hair?
I don't know.
Well, it could be. Anyway, so that's it for the election petition this morning. Joseph Akable, thank you very much. That's our court correspondent.